Good evening. This is Salam Immigration. Today is 21st of September 2019. I'm here to share with you something about immigration appeals. There is a process involved in the appeals, and there is a forum of appeals with multiple forums available for you. When a decision is made, like refusing leave to remain or extension of leave to remain, or refusing entry clearance to someone who wishes to come to the UK, then there is a right of appeal in not all but most of the cases. There is a right of appeal to the first year tribunal. So there are two tribunals. There is a first year tribunal and then there is an upper tribunal. When you file an appeal to the first year tribunal, there is a fee of £140 payable plus whatever you pay to the solicitors and your barristers. Then there is a full hearing before the first year tribunal judge who would listen to both parties. There will be someone from the Home Office, someone from your side, or you can go there by yourself as well and listening to the witnesses and the evidence and the submissions from both the parties. There will be a decision. If any of the parties is not happy with the decision, the Home Office or yourself, the migrant, both of them have the right to request for a permission to appeal to the upper tribunal. There is a permission involved here. That doesn't mean if they file an appeal, it will be heard. No, they have to file grounds of appeal to demonstrate that there is an error of law by the judge and that there should be permitted to take the matter for a full appeal to the upper tribunal. In the first instance, the application for permission to appeal is to be made to the first year tribunal. A judge of the first year tribunal sitting alone would decide on papers whether or not there is room for granting permission on the basis that the judge has made an error of law, which is not only an error but is a material error due to which the outcome of the decision has been affected. So, what he would do is he would say, arguably, there is an error of law since he has not heard the parties, so he would not give a conclusive decision that a certain point has been decided by the judge erroneously. These error of law proceedings are based upon errors of law and not errors of facts. There can be disputes of facts which do become an error of law, like if some evidence has not been considered or has not been given correct weight, this can be an error of law. If permission is granted, then the upper tribunal will issue a notice for a full hearing and both the parties will again go to the upper tribunal, and before the upper tribunal does anything, before they go for a full hearing, they will again decide whether there is an error of law or not. This time they will hear both parties and they will now decide whether conclusively really there is an error of law and that is material, and if it is material, should they cancel the decision of the first year tribunal, and if they cancel the decision of the first year tribunal, should they decide the case to remake the decision, or should they send it back to the first year tribunal, in which case the first year tribunal would rehear the case and decide it again. If the upper tribunal decides that the case should be allowed to proceed to a full hearing, they can remake the decision themselves. Then they can hear the evidence just like the first year tribunal and hear submissions from the both parties and decide the case fully themselves and decide as if they were the first year tribunal. If, as a result of that decision, any of the parties wants to challenge it further, they can make an application to the upper tribunal for permission to go to the Court of Appeal. Court of Appeal is a very senior court where lords would sit and decide cases. So permission is quite difficult here, and the criterion is not just an error of law or material error of law, but you also have to demonstrate that either there is public importance involved in this case or that there are compelling reasons why the case should be heard. And the permission is also granted on the basis that the case has good prospects. If, if the case is rubbish, it should not be allowed to proceed to the Court of Appeal. If the tribunal does not grant permission, then you can always file an application for permission to the Court of Appeal directly. That will be like a full appeal, and before the Court of Appeal can proceed with the full appeal, they will again uh, consider whether to grant permission or not. If they grant permission, that is again on papers, one of the lords would sit and decide whether to grant permission or not, whether the criterion for such permission is met or not. If they find out that the criterion is met, then they will allow the case to proceed to a full hearing. And in that full hearing, generally there are three lords who would sit and hear the case and decide the case. It is common that nowadays the Court of Appeal, before granting permission, sometimes would ask the Home Office or even the migrants to make submissions on a certain point where the Court of Appeal is not clear, or they think there is something more to be explained before they can reach a decision whether to grant permission or not. And sometimes when they issue directions for such submissions, the Home Office would understand that the Court of Appeal have gone to the root of the problem and they understand what it is, and they have hit at the right point, and that they may lose the case. So what they do is they then have a consent, they invite you for consenting to withdraw the appeal and to uh, accept whatever they are offering, like they will offer a reconsideration of the matter, or that the case should go back to the upper tribunal instead of going to the Court of Appeal. The court would be happy if there is a consent between the parties. If the consent is in accordance with the law, the court would not insist on the case to proceed unless there is something of real public importance, in which case sometimes the Court of Appeal would say, no, we will hear the matter. So there have been instances where the court has, like in the case of these English language test cases, in which the Home Office tended to withdraw the decision, and they presented a consent which they had negotiated with the appellant, but the court said no, this is a matter of importance. We do not allow this consent order, and we will hear the case. And then they heard the case and decided it against the Home Office because it was a matter which would have affected thousands and thousands of students. So the Court of Appeal is a very important forum, and it's very difficult to get permission there because they do not have the resources for uh, deliberating upon all appeals or all matters, big or small. They have to see whether there is a matter in which they should really interfere. And if the Court of Appeal decision is against you, then you can go to the Supreme Court only if the Court of Appeal has granted permission and they have heard the appeal and they have decided it against you. Then you can challenge that order in the Supreme Court, but again there is a permission hurdle. So all cases are still not heard by the Supreme Court because again the resources are limited, and it is in the public interest that cases of real importance or cases where there are really compelling circumstances should go to the Supreme Court. So this is a very short analysis or summary of the procedure and the process and the forums available for challenging matters in appeals. Thank you very much.